The Canadian government is running ads warning the public about the pitfalls of disinformation.
Disinformation is false information that's intentionally created to spread online quickly and mislead people. Get practical tips to identify disinformation at canada.ca/disinformation.
But as seen in the US, what if the perpetrators of disinformation are lawyers?
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
It is.
How do you plead to aiding and abetting false statements and writings under accusation 23 SC 190514?
Guilty.
Ms. Ellis is just one example, yet her admission of guilt in making false statements is a stark public reminder of the undeniable truth. Not all lawyers command respect or trust. However, this realization does little to alleviate the severe repercussions that can occur as a result of deceptive lawyer assertions. One casualty is often a total erosion of credibility brought about by pernicious disinformation. Exacerbating the situation further is that, in certain instances, the loss of credibility proves impossible to retrieve, leaving victims unjustly disadvantaged by nothing more than a disinformation illusion. Emphasizing the challenge individuals face when trying to combat deceptive lawyer statements, uploading a video addressing the issue of Morneau Sheppel lawyer disinformation on his YouTube channel, YYZ Bruce, he now admits, with the significant corporate stature of Morneau Sheppel, it is entirely possible that his video statements could be treated with skepticism and not immediately accepted as credible, and certainly not with Sheppel boasting on its website that it is one of the world's largest employee assistance program providers. Indeed, visibly, the impression conveyed is that Morneau Sheppel is a company of solid integrity. So this potential must be respected. If up against high-profile disinformation, how can the public discern that Bruce's rebuking critique of Morneau Sheppel and its lawyers, Pamela Mills and Roslyn Cogan, isn't merely just more disinformation? A new norm. There is only one safe way to deal with lawyer disinformation, and that is to investigate the veracity of all lawyer statements, and regardless of how plausible they may appear. In this case, openly naming lawyers who have disregarded the legal code to obstruct justice, it clearly compels a transparent clarification of legal facts that to date have been ignored by an egregious lack of integrity from within the Ontario legal industry.
What we're dealing with here is a complete lack of respect for the law.
So let's start at the beginning and dispel the possibility of disinformation in this video. In 2012, Bruce filed a civil case in Ontario's Brampton court alleging malpractice by Catherine Heyman, a Morneau Sheppel guidance counsellor. Heyman's reckless defamation had serious consequences, ending his relationship and putting his life in danger. Twice. Unwilling to let such unethical behavior pass unaddressed, Bruce presented conclusive documented evidence against Heyman that met the liable test. Due to the damage caused by Heyman's defamation, Bruce had to represent himself in court. However, regardless of his evidence satisfying the liable test, Sheppel still won the case. But how, if Bruce's evidence conformed to the letter of the law? Needless to say, the clue is, there is one constant when a company is caught doing something wrong: the cover-up is always worse. And when I say worse, the word worse doesn't describe it. From the onset, Bruce encountered obstacles in what should have been a straightforward legal process. His attempts to serve the necessary legal documents directly on Catherine Heyman were thwarted as Sheppel refused to disclose her contact information. This obstruction effectively halted the progression of his litigation. Complicating matters further, Sheppel's lawyers insisted that the litigation should be directed towards Sheppel rather than Catherine Heyman. Faced with this deadlock created by the legal maneuver, Bruce ultimately had to acquiesce to Sheppel's demand so the case could move forward. So the litigation commenced, and for laypersons to understand the significance of what went on, we'll start pointing out some laws and legal rules as we now go along. Upon receiving Sheppel's defense factum in advance of the case, it was immediately apparent that none of the statements appeared applicable to anybody named in the case. Indeed, at the start of the case, the first issue raised in court by the judge was legally sufficient to bring the case to a halt, before it could even begin. Addressing a serious error, Justice Blaby was unclear as to who Sheppel's defense factum was defending, and for the reason, in a stunning display of incompetence, lawyer Pamela Mills had forgot to identify and name Catherine Hayman as being the person Sheppel's factum was defending. Legal Code Competence 3.1-2 A lawyer shall perform any legal services undertaken on a client's behalf to the standard of a competent lawyer. So,
Strike one!
Pamela Mills quickly assured Justice Blaby that although not naming Catherine Hayman to be defended in Sheppel's defense factum, the facts presented were all legally pertinent to Catherine Hayman. Justice Blaby readily accepted Pamela Mills' candor and allowed the case to proceed. But why did he just accept her word given the issue? Well, quite simply, it's Pamela Mills' professional duty to treat the court with candor, fairness, courtesy and respect, and Justice Blaby clearly thought she had the integrity to do just that. Legal Code also states in 5.1-1 commentary 6, the lawyer must take particular care to be accurate, candid, and comprehensive in presenting the client's case so as to ensure that the tribunal is not misled. In forgetting to name and identify who she was defending, Pamela Mills plainly did not take particular care to be accurate, candid, and comprehensive, and so clearly this must be
Strike two!
What?
You have 2 strikes. 3 strikes and you're out.
So, strike 2, and we haven't even started the case yet, and all thanks to lawyer involvement. Regardless, let us proceed. As court protocol dictates, Bruce presented his compelling evidence which identified Hayman's actions as defamatory according to the established legal test. Pamela Mills did not contest the factual legal merit of Bruce's evidence, acknowledging its conclusive nature. This legal reality imposed a binary choice in Sheppel's case. Mills could either advocate for mitigation on behalf of her client or construct a sufficiently persuasive argument to dismiss the application of libel law. Her factum identifies, Mills opted for a strategy of mitigation while simultaneously challenging the applicability of the libel law, rendering libel law seemingly ineffectual. As mentioned, Sheppel won the case. But how did Mills pull it off? Having given his evidence, Bruce sat down and Pamela Mills stood up to present Sheppel's defense. Completely unsupported, her statements consisted of legal precedents and some licensing authority member ethics, and by appearance, it all looked plausible, but in reality, her case was, as can now be legally said, a fantasy fraud.
You got me shitting me!
No, it's all true. So, let's address the issues that made this case an illegal pleading and one that still must be addressed to satisfy law and legal code. First, let's remember that to commence the case, Pamela Mills had to legally confirm to Justice Blaby that Catherine Hayman was pertinent to Sheppel's defense factum statements. However, noticeable by her absence, and turning Sheppel's defense into nothing but hearsay, Catherine Hayman did not attend court to give any evidence in support of herself, nor did Hayman offer any written defense to counter Bruce's allegations against her, and nor did she provide any written statements in support of anything stated in Sheppel's factum. For all intent and purpose, Catherine Hayman took absolutely no part in any of the proceedings, despite Pamela Mills confirming she was pertinent to Sheppel's factum statements. Lucidly, with the absence of any supported facts, it rendered Sheppel's defense a collection of irrelevant random statements. However, Justice Blaby failed to observe the complete lack of material facts, and so from here on in, the judgment cannot fail to be legally unsupportable. And this despite the mandatory legal remedy identified in Rules 21.01, 3d, and 25.11. They empower the court to strike out pleadings that are scandalous, frivolous, or vexatious. A pleading that demonstrates a complete absence of material facts will be declared to be frivolous or vexatious. Pleadings that are irrelevant, argumentative, or inserted for color or that constitute bare allegations should be struck out as scandalous. The same applies to a document that contains only argument and includes unfounded and inflammatory attacks on the integrity of a party, and speculative, unsupported allegations of defamation. So should the case be struck out? Apparently yes, if we are going to uphold the precedent. Despite Sheppel's failure to provide material evidence to refute the libel test, Justice Blaby still sided with Sheppel's case, a decision inviting profound criticism, because as the evidence now determines, nothing in Sheppel's factum was pertinent to Catherine Hayman. That is to say, absurdly, Justice Blaby is now left on legal record siding with a person who was not being defended. Since the case, the legal excuses offered to evade addressing this case duplicity have been mind-boggling, but all having the outcome, by the legal industry doing nothing to address the injustice, all those involved have successfully protected the Sheppel lawyers from facing criminal prosecution for obstructing justice. But do members of the legal industry have a duty to address this case in justice, apparently removing all doubt? If conclusive evidence exists identifying lawyer fraud did obstruct justice, the legal profession is duty-bound to speak out against an injustice, and this is confirmed in Code Chapter 5, Relationship to the Administration of Justice. It states, a lawyer should not hesitate to speak out against an injustice. But having brought this injustice to the attention of the Ontario Law Society, Bar Association, and numerous others in the legal industry, the Ontario Law Society state, the lawyers have done nothing wrong, and the Bar Association, like everybody else, just didn't bother to respond back. So,
Nothing to see here, please!
Except, of course, there is everything to see here. Wholly fabricating their case, Sheppel lawyers' intentional fraud leaves no room for doubt as to their disinformation intent. So to its professional disgrace, let's fact-check some more to appreciate the extent of injustice the Ontario legal industry has been prepared to hesitate addressing, for now 12 years. Pamela Mills' first illegality was to verbally misdirect the judge into believing Sheppel's factum statements were pertinent to Catherine Hayman. Now legally verified, Sheppel's defense submission was nothing but an elaborate fraud designed to manipulate the court into believing a fantasy that would have it appear Sheppel's factum statements were pertinent to Catherine Hayman, when in reality they were extraneous. So having to be respected as fact, Mills lied to Justice Blaby. Let's just remind ourselves, and the Ontario Law Society, what the rules insist should have occurred. A lawyer must take particular care to be accurate, candid, and comprehensive in presenting the client's case so as to ensure that the tribunal is not misled. And, when acting as an advocate, a lawyer shall not knowingly attempt to deceive a tribunal or influence the course of justice by offering false evidence, misstating facts or law, presenting or relying upon a false or deceptive affidavit, suppressing what ought to be disclosed, or otherwise assisting in any fraud, crime, or illegal conduct. But the evidence unequivocally dictates, from the start, the tribunal was misled, and spectacularly so, based on the two mentioned rules. YYZ Bruce is publicly stating, the lawyers in this case, Morneau Sheppel's Rosling Cogan and lawyer in court, Pamela Mills from the law firm, Ed and Burles, are guilty of violating rules and legal code. And this can be legally said for the following reasons. Pamela Mills did not take particular care to be accurate, candid, and comprehensive in presenting her client's case so as to ensure that the tribunal was not misled. And if showing reasonable diligence to the case facts, she had to know she was deceiving the tribunal and influencing the course of justice by offering false evidence and misstating facts. Or was she just relying upon a false and deceptive affidavit from Morneau Sheppel's Rosling Cogan? Either way, Pamela Mills did suppress what ought to be disclosed, and here is the undisputable evidence that proves it. With Sheppel's factum statements not making any sense, Bruce, an ex-private investigator, had already started to investigate the validity of Sheppel's statements, but causing great confusion, the hearing date came without him being able to clarify any of Sheppel's factum statements. But regardless of the court judgment going against him, his investigation continued. So let's look at some facts that initially defeated Bruce's investigation, but with perseverance became clear. In Sheppel's factum, Pamela Mills provides the court with evidence of the standards of practice for members of the Ontario Association of Consultants, Counsellors, Psychometrists and Psychotherapists. The OACCPP for short. The OACCPP was the only licensing authority named in Sheppel's factum, and so it had to be assumed this was the on-point licensing authority pertinent to Catherine Hayman. Indeed, code mandates lawyers identify the on-point authority pertinent to a case, and as confirmed here by the lawyers, Mr. Robert Bell and Ms. Carolina Beeler, in their paper, A Lawyer's Duty to the Court. They state under, misleading the court on legal issues. Lawyers are under a positive duty to make full disclosure of all the binding authorities relevant to a case. This means that all such authorities on point must be brought before the court, whether they support or undermine the position being argued by that party, even if opposing counsel has not cited such authority. So it appeared that Pamela Mills was upholding code, but let's not hold our breath on this one. The OACCPP is a reputable Canadian licensing authority, except the quoting of OACCPP member ethics was not legally permissible in this case. The OACCPP are on documented record confirming OACCPP member ethics are only legally applicable regarding OACCPP members. Contrary to how Pamela Meal's inclusion of OACCPP member ethics would have it appear, nobody in this case was, or ever had been an OACCPP member and therefore against rules. The tribunal was misled by Sheppel's disinformation.
Strike 3!
Immediately this OACCPP reality identifies, by verbally assuring the Judge Sheppel's factum was pertinent to Catherine Hayman, Pamela Meals did emphatically and aggressively lie to the court.
Strike 4!
So incontestable, evidence dictates with Sheppel's extraneous factum not being accurate, candid and comprehensive as code requires, Pamela Meal's case was frivolous and vexatious, and that makes it legally unacceptable for the judgment to be upheld.
Strike 5!
Unquestionably aware of her lack of legal authority to quote OACCPP member ethics, Pamela Meal's actions demand accountability for the egregious harm caused undermining the principles of civil justice. And accountability becomes legally inescapable when to have it appear OACCPP member ethics were pertinent to the case. Pamela Meals had to substitute the legally authentic on-point authority that mandated code strictly requires, should have been disclosed to the judge. This flagrant substitution of the on-point authority once again renders the judgment worthless, and emphatically identifies transparent code violations.
Strike 6!
But let's look deeper into Sheppel's deception statements. The private investigation went on to reveal, Morneau Sheppel guidance counsellor Catherine Hayman was in fact not licensed to practice here in Canada, and this reality clearly offering ample reason to conceal her information from Bruce at the start of the case.
Strike 7!
However, the findings of the investigation reveal the technical intricacy to Pamela Meal's fraud. Identifying the severity of Pamela Meal's code violations, Catherine Hayman's authentic licensing authority, that should have been disclosed to the court, was in fact the Texas State Board, based in Austin, Texas, USA.
Strike 8!
It's at this point we see the powerful impact of an improper pleading using disinformation. Initiated by Bruce, the significance of Pamela Meal's failure to correctly identify the authentic licensing authority becomes evident following an inquiry by the Texas State Board into Catherine Hayman's unethical malpractice. And, in 2014, the Texas State Board concluded its inquiry into Catherine Hayman, that explicitly stated to her in writing, the board, however, advises you to adhere to and comply with all board rules, specifically, Code of Ethics. It is unequivocal that the board would not have possessed any legal basis to censure and advise Catherine Hayman to specifically adhere to the board Code of Ethics, if she had already been in compliance. This emphasizes the ethical inevitability of the court judgment being confirmed wrong, while also elucidating Pamela Meal's deliberate concealment of the on-point authority from the court. Thus, Pamela Meal's substitution of the authentic on-point authority did mislead the court as to not only the authentic on-point authority, but also the ethical position required to be upheld regarding Catherine Hayman's malpractice. Indeed, if Pamela Meals had not concealed the on-point authority from the court, other information could have been provided to the court to help make its judgment legally safe.
Strike 9!
In light of this irrefutable evidence, and more, able to be shown identifying Sheppel's case was fabricated, it is evident that legal action must be taken against the implicated lawyers for engaging in acts of bad faith and filing a meritless case. According to mandated legal rules, Sheppel's pleading has been conclusively proven to be frivolous and vexatious, warranting its immediate striking out in accordance with legal rules. However, despite the clear violation of legal principles, the legal industry has regrettably shown no inclination to hold these lawyers accountable for their reprehensible conduct that has undermined the very essence of fair justice. And this despite Pamela Meal's egregious obstruction of justice manifestly demonstrating culpability, identifying blatant professional misconduct. The misleading potency of her improper factum pleading cannot be justified within the bounds of legal sanction. However, inexplicable to date, her abuse of privilege has been allowed to persist without consequence. This ongoing disregard for fundamental rights to fair justice undermines the very essence of our legal system, and it's past time honourable members of the bar stepped up to address the egregious lack of integrity that has infiltrated and brought disrepute on the legal profession. The Ontario legal industry should take note of all public opinion. There can be no respect for an administration of justice if those running the system appear unconscionable, exploitive, and corrupt.